My name's Paul Jordan. I'm a partner in the brands, designs and copyright team here at Bristow's, and I'm delighted to see so many human beings in the flesh, not through Teams. I think this is the first big set piece in-person presentation we've been able to get away since the pandemic, and it's really nice to have everybody here. As you probably know, we're here tonight to talk about trademarks, designs, and copyright. The session itself will be broken into two pieces which reflect the publication, which will be with you all, I think, at the end of the month or around the end of the month. That'll be sent to you all. We're not going to go through all the cases. You may be disappointed or pleased to know that within the confines of those publications, but we decided we'd pull out some topical cases, ones that hopefully appeal to most people in the room. So if you're into designer shoes or handbags. Two sections. We're going to start with the brands review of the year. My people here, Team Broti, as we imaginatively call it. And then we're going to talk about Decroti, which you've probably worked out, designs and copyright review of the year. Three gentlemen over there. So Stephanie, one of our senior associates, will be first up. This is a partner-free zone, you'll be pleased to know, in terms of speakers. You only have to put up with me occasionally, but otherwise it's really a showcase for our wonderful team at all levels. So we have Steph, Shireen, Sean and Mark in the Broti crew, and Sean, another Sean, and Jake and Toby talking about designs and copyright later on. So without further ado, Stephanie, please get us started. Thank you.
Hi everyone. I'm going to quickly talk about a trademark cancellation decision that was issued last year. And so as a starting point, as you may already know, once a EU or UK trademark has been registered for 5 years, it can become vulnerable to cancellation on the grounds of non-use if the trademark owner hasn't put the mark to use in relation to the goods and services covered, or if they haven't got good reasons why they haven't done that. And that's what happened here. So Asia Standard applied to revoke the standard EU trademark registration for its upside-down standard logo shown on the slide, on the basis that they claimed that the mark hadn't been put to genuine use in the EU. And at that time, the standard hotels were operating in the US. They had a few hotels in the US. They were just about open in London, but they didn't have a physical presence in the EU. So the cancellation decision went against them at the cancellation division of the EU IPO. The Standard then appealed the decision to the EU IPO Boards of Appeal, and they looked at the criteria for establishing genuine use in a bit more detail. And one of those factors is looking at the place of use of the trademark, so where the services are provided. So the Standard had provided a lot of evidence to show that whilst they were not physically present in the EU, they were making efforts to attract customers in the EU. So that the evidence that they provided was invoices from EU customers, evidence of bookings to their their US hotels from EU customers, advertising campaigns that they had undertaken to try and attract EU customers to book the US hotels, and press and promotional campaigns that they'd run in the EU. So nevertheless, the Board of Appeal still upheld the decision of the cancellation division, and the Standard then appealed to the General Court. So the General Court overturned that decision, and they held that advertising and promotional activities for hotels would be sufficient to constitute acts of use of a trademark within the EU. So when they made that decision, they were looking at a distinction between the place where services are provided, which in this case was the US, and where the trademark was used. And they felt that advertising and promotion would be an act of use, means that the trademark had been used in the EU. So the takeaway point from this, it's a useful decision for hospitality service providers, because it can often be the case that the physical establishment might not be in the place where the trademark is registered. But I think what was particularly important here was that the Standard had kept really good records of evidence to show that they were trying to attract customers in the EU. And it shows the importance of being able to prove your case. And we always recommend that trademark owners hold on to evidence and are able to provide it. So in this case, they were able to hold on to their trademark registration.
Hi everyone, I'm Shireen Samnani. I'm going to talk about two cases in relation to 3D shape marks and the assessment of distinctive character of these marks in the EU. So we've got one from Dior and one from Samsonite. As a bit of background, and as you may know, the Guerlain lipstick case from 2021, the cosmetics company was actually successful in getting trademark protection in the EU for a particular lipstick case shape. And at the time, this actually let brand owners and practitioners become rather hopeful when it came to registering 3D shape marks. However, with the two cases I'll talk about today, it brings us back down to earth, and it reminds us that the Guerlain case is probably more of an exception to the rule. So in general, EU trademark law recognises trademark protection for shapes. And in theory, the criteria for assessing distinctiveness of 3D shapes should not be different to the criteria applicable to other categories of trademarks. However, in practice, the protection of 3D shapes as a trademark has proven to be extremely difficult and centres around two key points. So it's considered that consumer perception of 3D marks is likely not the same as it is for word or figurative marks, and distinctiveness is only assumed where a mark departs significantly from the norm or customs of the sector. So I'm first going to talk about the Dior case in relation to their application to register their saddlebag design at their 3D shape as an EU mark. So from a consumer point of view, and for those who are familiar with Dior or in fashion, with fashion in general, would agree that the saddlebag has achieved some kind of a cult status, even going on to say that it's iconic. The saddlebag was first designed by John Galliano in 1999 and has recently been reintroduced and crowned as a decade-defying it bag by Vogue magazine. However, when it came to registrability of the shape mark, the courts had a different view. So let's jump into the facts of the case. In March 2021, Dior applied to register the 3D sign you can see at the top left-hand side of the slide as an EU trademark for various goods in Class 9 and Class 18, including bags, leather goods, and spectacle cases. The EU IPO partially rejected this application for lack of distinctive character, and the original application was dismissed for the usual reasoning, so that the average consumer of such goods would rarely rely on the shape alone to make a purchasing decision, and would also look at the accompanying words or logos of the product itself. And ultimately, the EU IPO considered Dior shape was considered as a mere variant of the shapes available on the market and didn't significantly depart from the norm. So Dior appealed this, as they obviously weren't happy with this decision, and noted that its sign would possess inherent distinctiveness for the following reasons, among others. So firstly, that their goods are luxury products and that the relevant consumer have a higher level of attention. And secondly, the sign actually resembled a horse riding saddle, which in the industry, this is never done before. And they had provided examples of similar luxury products with a different shape. Dior also made the claim that in the alternative, the applied for shape has acquired distinctiveness through use. The second Board of Appeal examined in particular if the applied for shape mark has distinctive character and whether the mark demonstrated a significant departure from industry standards. It considered that if the mark consisted of the appearance of the product itself, it might be more difficult to actually prove the established distinctiveness than a word or figurative mark that is a sign independent of the appearance of the product. And as a result, the consumers don't actually tend to see shapes of the product itself as indicators of commercial origin, even if it's as recognizable as the alleged sign here. The rapporteur also identified bags such as the bottom left-hand side of the slide and suggested that the Dior's shape wouldn't diverge sufficiently from the norm and customs of the sector, giving this bag as an example. So as a result, the board actually upheld the refusal to register the EU trademark applied for in relation to bags, handbags, pouches, leather goods, toiletry and makeup cases, but actually allowed the applied for mark to be registered in the remaining goods in class 9 and 18. So there was a partial refusal of the registration. Whilst Dior's mark was refused for these goods for lack of inherent distinctiveness, the case actually remains to be decided for acquired distinctiveness, and the board has remitted the case to the EU IPO examiner for consideration of this second claim. So this decision adds to a long list of cases for 3D shape marks where the signs are deemed non-distinctive or otherwise unregisterable, including the next case that I'm going to talk to you about today. So here we have the luggage manufacturer Samsonite, who applied to obtain the 3D shape mark registration for the shape of the tablet case that you can see on the left-hand side here. The EU IPO initially found that the mark was devoid of any distinctive character, but then waived this objection to go on to say instead that the shape was necessary to obtain a technical result and therefore was refused registration. This decision was appealed by Samsonite, who made the following arguments: that the cartoon figure, the design, makes it sufficiently stand out enough to indicate badge of origin, that no other products include arms and legs and have the appearance of a cartoon man, and actually provided examples of this. And thirdly, in the alternative, Samsonite also argued that the mark had acquired distinctiveness through use and submitted evidence as such. So what does the Board of Appeal decide? Second Board of Appeal dismissed the appeal on the grounds of lack of distinctive character. Since the mark has already been rejected on those grounds, they didn't actually go on to consider whether it consisted exclusively of the shape that was necessary to obtain a technical result. Yes, the board then held that the mark was functional in nature and therefore incapable of conferring distinctiveness of the mark and would not be seen as an indicator of commercial origin. It was also considered that the overall impression did not sufficiently differ from those that were in the industry and the norms and customs of the sector. On this slide, you can see some of the examples of the already existing tablet cases that they looked into and they took into consideration whilst making this decision. And you can see, yeah, some of them do have arms and legs and look like a cartoon man. The board also once again confirmed that whilst the criteria for assessing distinctive character of the 3D trademarks are not different to those applied to other categories of trademarks, the perception of the average consumer is not necessarily the same when comparing 3D marks that consist of the appearance of the product itself, like we have here with the tablet cases. The board noted that if a shape is a variant of a common shape, this isn't sufficient to establish that it is not devoid of any distinctive character, and it must depart significantly from the common shapes expected by the consumer for this type of goods. So what are the take-home messages here? Essentially, the strict approach taken by the EU IPO is still in place. We'll wait to see how the Dior case progresses, and we look forward to see what happens there. But for the moment, there doesn't seem to be much movement on the difficulty for shape marks to establish they've reached the required level of distinctiveness. Thanks very much.
The next case is of Coom International and Dr. August Wolf, which is an important case because it really helped clarify the test of the defense to infringement of acquiescence. And so to understand the Court of Appeals decision in this case, it's important to know about the background. And so Coom International's product and mark for Vagisan was launched in 1984. And that's when they started selling their product in the UK. In 2013, Dr. Wolf, under the mark, Coom launched Vagisil in 1984, and Dr. Wolf launched Vagisan in 2013. In 2014, Coom became aware of Vagisan being sold in the UK, which is important for commencing the 5-year period for the defense of acquiescence, which we'll go over go over on the next slide. In 2016, the advertising for Vagisan was increased, and the product became more widely available on the market and was sold in pharmacies such as Boots. In 2017, Coombe commenced cancellation proceedings at the EU IPO, but it wasn't until 2019 that they commenced infringement proceedings in the UK court. And in 2020, Dr. Wolf started to rebrand its product from Vagisan to Dr. Wolf's Vagisan. So the High Court decision was that Dr. Wolf's use of the mark Vagisan infringed Coombe's marks, and Dr. Wolf tried to rely on the Defense of Acquiescence, which is in Section 48 of the Trademarks Act. And so just to paraphrase, the Defense of Acquiescence is essentially that where a proprietor of an earlier mark has acquiesced for a continuous period of 5 years to the use of a later mark while being aware of the later mark, then the right to invalidate the later mark or oppose its use is lost. The High Court decided that there is no acquiescence in this case because the commencement of the cancellation proceedings in 2017 had interrupted the 5-year period, and this was contested at the Court of Appeal. So Dr. Wolf's argument was that the 5-year period for acquiescence had elapsed between 2014, when Coombe became aware of Vagisan being used, and that this awareness continued for a 5-year period right up until 2019, when the infringement proceedings occurred. So the grounds for appeal was that Wolf argued that they should be able to rely on the Defense of Acquiescence, that there was no likelihood of confusion with their new mark or the rebranded mark, which was Dr. Wolf's Vagisan. Coombe, on the other hand, argued 3 main points. Number one, they said that they had interrupted the 5-year clock through their cancellation action, which was in 2017, so 2 years before the infringement action. Coombe also argued that Dr. Wolf had not been using this mark continuously in the UK throughout the 5-year period. And they said this because there was a period of about 1 year between 2014 and 2015 where Dr. Wolf had only sold about 500 units of their product within that time period of 1 year. And so Coombe's argument was that this was not continued use of the mark. The third point was that they themselves had not been continuously aware of the later mark for the entire 5-year period. And those were the three points that were before the Court of Appeal. So the Court of Appeal actually disagreed with the High Court's approach to determining the interruption of the acquiescence period, but ultimately upheld the infringement ruling. So they disagreed on point 1, that Coombe had interrupted the 5-year period by filing the cancellation action. They also disagreed on point 2, that Dr. Wolf had not been using their mark continuously throughout the 5-year period. But the acquiescence defense ultimately fell on point 3, in that the Court of Appeal agreed with the High Court that Coombe, in fact, were not aware of the mark for the entirety of the 5-year period because of this 1-year period between 2014 and 2015, where only 500 units of the product were sold. Coombe had a genuine and reasonably held belief that the product had exited and no longer being sold in the UK. Even though this belief was not entirely correct, they claimed that they had not been aware that it was being sold, and the Court of Appeal agreed with this. And so just to examine all 3 points in a bit more detail, we'll do this on the next slide. So on the first point, whether commencing cancellation proceedings does in fact stop the 5-year clock, the Court of Appeal decided and ruled that sending a cease and desist letters or warning letters does not suffice to stop the acquiescence period. Further, this administrative proceedings, such as a cancellation action, will also not necessarily suffice. Only bringing legal proceedings for the trademark infringement will suffice. And this is because of bringing a cancellation action, you are objecting to the registration of the mark and not necessarily to the use of the mark. And it is only through bringing infringement proceedings at court that you're actually objecting to the use of the mark. So it was ruled that the cancellation action in 2017 had not in fact interrupted the 5-year period. On the next point of continued use, the Court of Appeal said that use does not necessarily have to be continuous, but it must be continued, which seems like a bit of a fine distinction. But they use the example of certain products that are only sold at certain times of the year, for example, Easter and Christmas. Just because these products are not, and the mark is not used every week of every month of the year, that does not necessarily mean that it is not being continuously used. It is not being continuously used, but there's still continued use for the sake of the acquiescence period. And the third point on awareness, which is where the acquiescence defense fell, Coombe claimed that they were not aware of the use of Vagisan for this long period between 2015 and 2016 because only 500 units had been sold and because the product was no longer advertised in the UK. And what was important was that Coombe had been actively keeping a watch out for use of the mark, and despite the fact that they were making efforts to see if their mark was being infringed, they could see no evidence of the product on the UK market, even though it was present, but just had a very small presence. So the Court of Appeal decided that Coombe were entitled to think the product had been withdrawn from the UK market, and they could not have been said to have been acquiescing to the use of the mark because they had a genuine and reasonably held belief that the mark was not being used in the UK. On the secondary point of the likelihood of confusion, the Court of Appeal upheld the High Court's ruling that there was a likelihood of confusion with both Vagisan and Dr. Wolf's Vagisan. This is because the Vagisan element played an independent and distinctive role in the composite sign, and simply adding Dr. Wolf's onto the beginning of the sign did not remove the likelihood of confusion. So the two important lessons I think to take home from this case is that if a trademark owner wants to avoid the possibility of the defense of acquiescence defeating their infringement claim, they need to bring legal proceedings in the court. And merely bringing a cancellation action will not be enough to interrupt the 5-year period. And this is because bringing a cancellation action, you're merely opposing the registration of the mark and not necessarily its use. Whereas if you bring infringement proceedings, you're opposing the use of the mark. So this is a fail-safe way to stop the 5-year period for acquiescence. And the second point is that if a trademark holder has a genuine belief that the use has stopped for a period of time, that is enough to interrupt the 5-year period. Even if the use of the mark has not stopped, if you believe and you're not aware that that mark is on the market anymore, you cannot be said to be acquiescing to the mark. And yeah, those are the key take-home messages from this case.
Hi everyone, my name is Mark, and I'm going to be discussing two cases that deal with the liability of online platforms. And those two cases have a common thread in that they both involve the advertisement and sale of goods on Amazon's online marketplace. The first decision that I'm going to look at is the Court of Justice decision in Louboutin. And now this case concerned a dispute over the alleged infringement of the Benelux trademark protecting Louboutin's famous red sole. And third parties were selling allegedly infringing counterfeit products on Amazon's marketplace and advertising sales listings via Amazon. And Louboutin issued infringement proceedings in Belgium and Luxembourg, alleging infringement and alleging that Amazon had infringed the Benelux mark by allowing the third parties to sell these counterfeit products via its platform. As I'm sure many of you know, trademark infringement requires unauthorized use of the sign. And that was the key issue in this case. So whether Amazon could be said to be using the allegedly infringing sign, which was the red sole of the Louboutin shoe. So the issue of use by online platforms has been considered in a number of Court of Justice decisions, and the court has set out some fairly well-established principles, some of which I've set out on the slide. I think the main point to flag is that the legal test in this context is whether the use is part of the platform operator's own commercial communication. And historically, the CJU has taken a fairly conservative approach to the liability of online platforms in this context. One key difference in this particular case was the nature of the marketplace, because Amazon was considered to be a hybrid marketplace because it sells its own goods alongside the goods of third parties. So the Belgium and Luxembourg courts effectively referred two questions to the Court of Justice. The first was, can a hybrid online seller itself be using a sign when a third party offers products under that sign on its platform? The second question was a related question, as whether the perception of users is a relevant factor in that assessment. In short, the court said yes to both of these questions and ruled that Amazon could, in principle, be held liable for trademark infringement in relation to advertisements for the fake Louboutin shoes placed on its website by a third party. In reaching that finding, the Court of Justice provided some guidance on the appropriate test in this context and clarified that it's focused on consumer perception and boils down to whether the advert or the listing in question enables a reasonably informed user to understand who is offering the product in question. If the answer to that question is yes, and users can distinguish who's offering the product, then the online marketplace is not using the sign in question. If the answer to that question is no, and it's indistinguishable who's offering the product, then it's arguable that the platform is using the third-party sign in question. Helpfully, the Court of Justice did outline some factors that would be relevant to this assessment, and that might indicate that a platform is using a sign as part of its own commercial communication. And again, these are the factors that would be perceived by the consumer in the context of assessing that issue. So one of those is a uniform method of presenting products and adverts on the marketplace. So if they follow the same format or they're presented in a similar way. And also a related factor is displaying advertisements for the operator's products alongside the third party's products. Another third factor was if the marketplace operator uses its own logo on the advertisements of third-party products. And a fourth factor, which was slightly more nebulous, was if the operator provides additional services to the third parties who offer and sell goods via its platform. So these are all factors that you would look at when assessing whether a particular advertisement or listing could be perceived by the average consumer to be part of the platform's own commercial communications. So I think it's important to note that the Court of Justice decision is not a finding of infringement against Amazon. What it is, it's a decision on whether Amazon in principle could be directly liable for trademark infringement. Even so, there are a number of points to flag, and there are a number of key takeaways from the decision. The first is that the decision is fairly significant in that it marks a departure from the existing case law for online intermediary liability in this context. And as a result, operators of hybrid marketplaces are now at greater risk of direct liability for the advertisement and sale of third-party products. And a related point to that is that these marketplaces are now more vulnerable to actual claims from rights holders, because these large marketplaces tend to have much deeper pockets than the third-party counterfeiters, and therefore are a more attractive defendant for right holders looking to enforce their rights. The third point to note is that the Court of Justice has now indicated that the focus for this test is on consumer perception. So it's all about how the consumer would understand the relevant listing or the advert. And if they can distinguish between who's offering the advert or the sale or the listing, then that's the key question in this context. A related point is that the question of use is likely to turn on the facts of each case, and the kind of appearance and presentation of the marketplace in question will be key to understanding how the consumer is likely to perceive advertisements and sales listings. As I mentioned, the Court of Justice did provide some guidance on the circumstances when these listings and advertisements are likely to be perceived as part of the platform's own commercial communications. But I think it's fair to say you can look at those with some skepticism as they were derived from the characteristics of Amazon's marketplace. So it's unclear how they'll be applied to other forms of hybrid marketplace that don't necessarily mimic the characteristics of Amazon's marketplace. But all in all, it's a fairly significant decision and does mark a departure from the way the CJU has approached this issue previously. The second case I'm going to look at is the Court of Appeal decision in Lifestyle Equities, and again, Amazon. Now, this dispute was quite interesting in the sense that it rose from the split ownership of rights in the Beverly Hills Polo Club brand. So the claimant, Lifestyle Equities, owned the UK and EU trademark registrations for the branding, but did not own the relevant US rights. And Lifestyle Equities alleged that Amazon had infringed its rights by advertising and selling US branded goods to the UK and EU consumers via Amazon.com, which is Amazon's US or global platform. And again, as I'm sure you all appreciate, for trademark infringement, there needs to be use of the particular sign in the relevant territory. So for a UK trademark, that needs to be use in the UK. For an EU trademark, that needs to be use in the EU. And that was the key issue in this case, was whether the use on Amazon.com was use in the EU and in the UK. Now, in an online context, the key concept is one of targeting, which is what the court uses to determine whether a particular online use is directed to the relevant territory. And again, that was considered by the court at first instance and on appeal. Unfortunately for Lifestyle Equities, the claims at first instance were rejected by Mr. Justice Green in the High Court on the basis that the advertisements on Amazon.com were not targeted at the UK or the EU, and therefore did not amount to use in either territory. On a related point, the judge found that the actual sales to UK and EU customers also did not amount to use in the UK and EU because they had not been preceded by offers for sale or advertisements targeted at the UK or EU. Lifestyle Equities, understandably, appeals that decision, and Lord Justice Arnold gave the leading judgment in the Court of Appeal, and he was effectively required to determine two issues, which I've set out on the slide. And the first was whether the advertisements and the offers for sale on Amazon.com constituted use in the UK and EU. In other words, whether those advertisements were targeted at either of those jurisdictions. And secondly, even if those advertisements were not targeted at the UK or EU, were the actual sales of goods to UK and EU consumers use within the relevant territories? So dealing with targeting first, Lord Justice Arnold was fairly critical of the way that this issue had been dealt with by Mr. Justice Green at first instance, and he was critical on a number of grounds. The first was that Lord Justice Arnold said the trial judge placed too much emphasis on the targeting of Amazon.com generally. So he'd been persuaded by Amazon's argument that Amazon.com was targeted at the US generally, and had failed to properly then consider each instance of use, so each advertisement for sale or each offer for sale. And that was an error in his assessment. Lord Justice Arnold also rejected Justice Green's finding that the notion of targeting imports the idea of taking deliberate aim at consumers in a particular territory. And Lord Justice Arnold stressed that this gave too much weight to the subjective intention of the marketplace operator and who the marketplace operator intended to target its goods to. Lord Justice Arnold clarified that subjective intention is relevant to that assessment, but it's not determinative. So even if the marketplace operator intended to target its goods at a particular jurisdiction, that does not preclude the goods from being targeted at other jurisdictions. So if the focus was on the UK, it doesn't matter necessarily. The goods can still be offered and targeted to the EU. After criticising the judge's approach, Lord Justice Arnold went along and reviewed a kind of sample transaction through Amazon's website, and he decided that it was fairly clear that the features of Amazon's website, even Amazon.com, were targeted at the UK, in the sense that those features emphasised delivery to the UK, focused on the GBP currency, and made it fairly straightforward for UK customers to order via Amazon.com. Turning to the issue of actual sales, the judge was similarly critical of the judge at first instance approach on this issue, in that he said that Mr. Justice Green had misapplied and misinterpreted the case of Blomqvist, which was another CJEU decision. And Mr. Justice Arnold decided that in the case of a sale to a person in the EU and UK, it is not necessary to consider whether or not that sale has been preceded by an advertisement or an offer targeted at the relevant territory. The sale itself is enough to constitute targeting and qualify as use in the relevant territory. So based on that analysis, Lord Justice Arnold confirms that the sales of US branded goods via Amazon.com to UK and EU consumers constituted use of the signs in the relevant territories, so in the UK and EU, and thus constituted infringing uses. And he reached that conclusion even though the preceding advertisements and offers for sale were not necessarily targeted at the UK and EU. So what are the key learnings from the Court of Appeal decision? Again, on the issue of actual sales, the decision clarifies that the sale to a UK consumer amounts to use in the UK, irrespective of whether the prior offer for sale and advertisement is targeted at the UK. So this means that effectively passive or unsolicited sales that have not necessarily been pushed to a consumer in a particular location can constitute use in the UK and EU for infringement purposes. So businesses, online marketplaces, e-commerce providers will need to think carefully about all of the locations in which they ship product to and sell product to, because that use could potentially qualify as infringing use in the EU or vice versa in the UK. And the last point is that when you're looking at actual sales, it's not necessary to consider the targeting of the prior advertisements or the offers for sale. You don't need to have that as a condition for the sale to qualify as use in the UK or the EU. On the concept of targeting, the Court of Appeal decision says that it's key to focus on the specific uses in question and not be too distracted by the overall context of the website or the platform in question. The targeting of the website and platform is not necessarily conclusive for the specific offers or advertisements on the platform. The Court of Appeal decision also emphasises that subjective intention of the operator is not a requirement for targeting, but is relevant to the overall assessment of targeting generally, and a factor that the court can take into consideration when assessing particular uses. And the last point, which relates back to the actual sales, is the fact that that a physical sale has been made to an EU or UK customer does not mean that the prior advertisements for sale were targeted at the UK or EU. It's part of a separate assessment and requires an assessment of all of the uses that are alleged to infringe. So that's all from me. I'll pass it over to Sean or PJ.
No, me. I just feel like I need to say something. Good. But first of all, thanks, Mark. That was excellent. Sean, Shireen, and Steph, thank you very much.